Yes, sir.
Your Lordship, I will like to mention item number 10.
10.
Yes. I'm for the respondent number 5, private respondent.
You're for private respondent.
Yes.
Ah.
Your Lordship, yes, the conducting counsel is out of station.
Who is conducting counsel?
K. Tagyang.
K. Tari.
K. Tagyang.
Tagyang.
Yes.
His name is not there.
I filed the wakalatnama this morning, Your Lordship.
Okay. Service is complete. That was the service was awaited.
It may be taken up after
Mr.
4 weeks.
Your name?
J. Taipuria.
Mr. J. Taipuria, learned counsel, appearing for Mr.
K. Tagyang.
K. Tagyang. Learned counsel, appearing on behalf of private respondent. Yes. Respondent number 4. 5. Submits that the leading counsel, Mr. So-and-so, has some personal difficulty today. Therefore, prays for listing the matter after
4 weeks.
4 weeks.
My lord, there is an interim order. Interim order may continue.
Prayers allowed. List after 4 weeks. Interim order first said continue.
Call it.
Office note indicates that service and respond number 5 is completed. It is. Which 5? Respond number 5?
Private respondent.
Okay.
Last.
Since the learned counsel, Mr. So-and-so appears. No, it's then in that case, respond number 5, huh? Not respond number 4. I said respond number 4. Yes. Yes.
My lord, I like to mention item number 13.
13.
Yes, on behalf of M. Biswas.
M. Biswas.
Yes, Lord. I mention on behalf of M. Biswas.
I think this is regarding with the state. State. That is connected matters.
Oh, yes.
Can we take up this matter?
No issue. Tomorrow.
No.
Yes, Lord.
Can we take up this matter? This court.
This court. No.
Because that connected matters. It's a challenging the amended rules.
Amendment.
I think why not? Who is appearing for private respondents?
In this particular case, lawsuit has not appeared in this particular case.
But then
in
the-
connected case, it might have appeared.
Connected matters. Because after the amendment, there were two groups.
Yes.
One is challenging the relaxation of requirement of graduation, and other they said it should be as per the rules. You cannot relax it. So one in single bench.
That was the issue of relaxation.
Yes,
Here, they have challenged the amendment rule.
but it's connected. Connected. Because these respondents,
Yes.
who have challenged the relaxation, they are the party to it. Is not it?
Yes.
They are not. Yes. Yes. But this private respondent they are the we cannot take up this. List this matter before any other appropriate bench without one of us within bracket. My name, huh? Yes.
Your Lordship, same order may
Item
be-
12,
Yes, Your Lord.
list this matter before appropriate bench without one of us within bracket meet. Huh?
Your Lordship, here we have not received a reply.
Huh?
Not received the reply.
Here our affidavits almost ready. We didn't want to.
What is it? Why you are claiming? You basically wants that it should be released.
Yes, Your
It's
Lordship.
a habeas corpus petition.
Yes, Your Lord, because
Then-
the detention is illegal.
How do we know now, without, before adjudication?
Because
There is no finding that it's an illegal.
Yes.
If there is a finding.
Yes.
After, if we decide that there is an illegality, then only you
Then-
may entitle for compensation.
Yes, Your-
Have you prayed for
yes,
compensation? in this
compulsory.
matter? What do you want?
After we,
Mr. S. Tapit, London Council, London Senior Government Advocate. President, he may be granted 1 week's time to file affidavit in opposition.
Yes.
We are not being objected to by Mr.
ठीक है.
T. Gary. London Council for the petitioner. Prayer will allow list after a week. So as to enable the London Senior Government Advocate to file counter affidavit.
here we have already filed our.
Yes, but then 226,
Yeah, 226.
all have been released.
All
There's-
have been released,
There's
all
no, there's no prayer for compensation.
my lord,
Will
there's
not
no,
consider, sorry.
no, in fact,
You file an appropriate application,
no, we want
will
to
consider.
pray for the amendment of petition.
Huh? You file a prayer.
Or we are insisting that this order should be declared as illegal. That is our.
You have to introspect yourself also.
No, in fact, our prayer in this petition is that the way this Arunachal Pradesh unlawful activities was used against them. that-
With clean mind, clean heart, clean objective, you have to introspect yourself also. It is not one-way traffic.
But then the act should not have been used against
So
them.
we'll
That is-
dismiss it or we will file appropriate application or close it down.
My lord,
You see, item 1, we have allowed, we'll hear it because there's a prayer for compensation.
my lord, it's the extraordinary. Your honorable court has an extraordinary
No,
power, my lord.
everything cannot be extraordinary.
When
You
there
have
is
to,
a-
basic thing has to be pleaded.
when we have alleged that there is a clear violation of the
What's
act.
the problem of filing a press petition claiming compensation? We'll see that. Basically, you have it's a habeas corpus for release of the destitute. They have been
Yes.
released now.
Yes,
We'll
that-
close it down.
that
Or if you insist for compensation, we'll dismiss on merit. We'll consider and dismiss on merit.
then my lord, I may have given some time, at least. Because they have filed the counter affidavit. And I have not gone through also. My lord,
There's a justification for your detention.
Yes, that's true. Yes, that is different, yes.
If it is not declared illegal, how can this court come and consider your compensation?
Yes, my lord, that is there, my lord.
That's why I'm
Then-
asking.
Then, my lord, we may take some time, otherwise,
Think over it. We'll grant you some time. Next week.
next we will take appropriate step after consulting with
And
my
please
clients.
introspect yourself.
Amendment may not be proper.
Think over it.
Obliged.
We're only granting you to take a,
Yes, yes.
whether to
Like, if what's
Close
the
it down.
law On that, please educate us also.
Obliged. That's- 1 week. please.
But we're firm.
Okay. I'm like 1 week
on
time.
the prayer of Mr. S. Learned Counsel for the petitioner. List these matters after a week so as to no, it's okay. This matter after 1 week.
I'm like,
But our this thing is very clear. There's no prayer, we cannot consider it.
the same.
Same.
Till,
Two- 2 to 6.
5.
5, sorry. What about 6?
Six
Is also same.
Other lawyer.
Other lawyer. Same.
Gadi is.
Six is a different state.
No, it's the same thing. Have you prayed for compensation?
No compensation here, illegal litigation here.
That's okay.
Nature of
It's
case is
the
different.
nature is same.
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 You're
Heard Mr. So
You're-
learned counsel. Just wait.
I think item 6, we have make it persons. Therefore, the direction may be issued to the issue notice to the private extension 4 for taking step. Last time I prayer, but the board is not reflected.
First, this is what? 6, item 6. You think it's- Then same order, 2 to 5, huh?
When did you read from Congress? Only
Item number 4, sorry, the respondent 4.
no notice has been issued.
No.
How do you think about?
You also see these are as well the private school is the deputy commissioner and chief state officer.
By post already he is there. By post is already a party here.
The district minister come.
Yes, Yes. And we have already filed our affidavit also. And here also he has been already,
What cases that order was interfered with? First order of detention was interfered with.
this is another incident.
Then
This order is of different incident.
Finished, then this.
This incident,
This is not 25%.
yes.
Still not all. 3 months period.
Yes.
For detention. I think it's 3 months.
Initially, no, not 3 days. It was for 12 days. 12 days.
What is the entry order?
But he has been already, he has given, yes, he was not even detained.
For this 25%.
This is pre-detentions
Order, but
yes.
this was not implemented.
not implemented. And this honorable court allowed,
So you are British, you are released and there is no prayer.
No compensation. You already the detention order is illegal, but the order is still stay the detention order.
Interfering with your.
Yes. They have not implemented it also.
You're not
We'll see after 1 week. Next week. Same.
notice may be issued to the private respondent 4. But we may be able to take step.
Yes,
What things he'll improve by appearing as a private respondent? What is the allegation against him?
Allegation is that because he the
He acted as a district magistrate.
district magistrate, he is the chief state officer.
He cannot.
Chief state officer. Your lordship.
Can he or can he not?
No, your lordship, here the private.
Illegality, your allegation of acting illegal
Yes.
or illegality is one thing. But a person,
Because your lordship is here.
why he has to be by name? As implemented as a by name.
Talapur, by name is,
Anyway, it's insisting on this notice. On the insistence of the learned counsel, Mr. So and so learned counsel to the petitioner. Notice be issued to the respondent number 4. The learned counsel for the parties shall take steps for service of notice upon respondent number 4 by registered post as well as by usual process. Within 2 days. List after 4 weeks. Make it 4 weeks. We'll consider.
Seven and eight is,
Can I appear? Anganwadi, all those series of connected
Yes.
matters. Because I vaguely remember, I said, we cannot implement.
yes.
Unless the central government.
The central government. Central government was supposed to file.
They have
affidavit.
filed. Yes. They have filed. But
List before any other appropriate bench. Without one of us, who didn't break it.
Followed in item 9,
No,
petitioners
the name of the-
council. Yes,
CS doesn't support.
they have not appeared on several occasions, madam. We have filed our affidavit. Their allegation was that NIT, without floating NIT, work has been awarded. Item 9.
You have plotted 6
Yes,
times,
madam, 6 times.
and thereafter you have asked
Yes.
for from the PSU.
Yes.
We'll give them one more chance. Do you know? And now, the name of the,
Outstation councils, madam. In fact, on the last occasion, notice was issued to the petitioner.
so should we? What do you say? Can we appoint, since it is a PL? We'll appoint.
Yes. My question.
The non-appeals for the petitioner on the whole. It is
Explaining.
not state on certain occasions. When the matter is
Yeah.
called up. Non-appeals for the petitioner. Since the petition has been in the problem. Yes. How do we go in this? Okay, we'll see next. We thought of appointing amicus, then in this case, that will same order, but, in view of the above, this is the, oh no, what is that? Eight.
Registry को implement करने गया था ना last time.
But the order dated 8/8/2023, this court has noticed that the name of the petitioner, the learned counsel of petitioner have not been registered in the CIS system. Therefore, the names of the counsel for the petitioner should not be reflected in the cause list system. In view of the above, registry is directed to no, this is directed to inform the council. List this matter after
As well as the petitioner, madam.
council for the petitioner,
As well as the petitioner in person, otherwise.
as well as the petitioner in person. List after 3 weeks. After 3 weeks? 3 weeks.
Going on. Wow.
Give the date after 3 weeks.
Always.
Particular.
My name may be also not. Now for the respondent number 5.
Mr. So-and-so, first, Mr. After the non appears, Mr. N. Ratan Learned Additional Advocate General, FS4, State Respondent, and Mr.
Tigaram.
T. Garam. For respondent number?
Five.
Five.
Deeply.
May I please? Your Lordship, I'm appearing on behalf of Mr. Rintu Seke, Your Lordship.
Service report.
Still awaited here. So, office
When
note,
did you take the step?
office note 2011-23 reflects the service report.
She's here and one.
Yeah, yeah, Lordship.
Why can't we, she's working still.
No, Your Lordship, there is a stay over here.
Still. So office note dated 2011-23 reflects that service upon respondent number 1 is still awaited. This matter after 3 weeks. This court finds no infirmity in the impugn order dated 3/3/2022. Accordingly, criminal litigation is dismissed. Yes. 21. What do you want?
For 2 weeks, taken consent from the
Contempt.
content.
Mr. R. Koi, Dalit Council, appearing
On behalf of Peter.
on behalf of Mr. T. Tagore, Dalit Standing Council, press for and granted 2 weeks. 2 weeks.
And
List after
item
2
number
weeks.
26.
26. Why? It's 2018 matter.
For 1 week, taken certain difficulties for certain difficulties.
What is the difficulty? Mr. Tagum,
Yes.
2018 matter. What is? You have no objection.
I would have liked to do
I
it
think,
yesterday, but
on the other day, this court has taken up this matter. It's a land dispute
yes,
where
yes,
the,
yes,
the,
yes.
the establishment of the PHE.
Yes, yes. Lordship,
That-
if
that-
they're asking for
that
1
is-
week, can it be taken up on Monday, Lordship? I would have liked to do, but since Mr. Tagum has
Madam, I
requested
don't
me.
want to dismiss all your cases. This is one of the cases. Right, some other court. After 3 weeks. Right,
Obliged.
I've gone through it, where you have argued certain length
Yes,
in this matter.
yes,
I find nothing.
obliged.
Of course, I should not say before hearing. On the joint prayer of the Land Council for the parties. List this matter after a week for hearing.
My lord, I may be, I'm praying for listing of one writ petition for tomorrow.
Is it new
No,
matter?
no, not new matter.
What is the issue?
My lord, this pertains to service matter.
Hmm.
So I'm seeking listing of the matter for tomorrow for withdrawal.
Withdrawal.
Yes.
Okay.
Yes, and
Yes.
I may be allowed to make one unlisted item, tender matter.
Tender matter. But no stay.
Maybe. Your Lordship, I may be allowed to withdraw item number 22, Your Lordship.
20,
2, Your Lordship.
22.
Yes, sir.
On the Mr. Ibam, London Council for the petitioner submits that he may be allowed to withdraw this. Allowed to withdraw the contempt petition. Prayer is allowed. The contempt petition stands closed on withdrawal.
One more item, Your Lordship, item number 27. Can this matter be
27.
taken up on 29, Your Lordship? I have taken consent from the opposite party. Your Lordship.
What is this?
So, CFP, Your Lordship, Mr. Limibam is the conducting counsel in this case and he's out of station on some personal difficulties.
You are who? What is there? Nothing.
He's a better person to argue this matter, Your Lordship, since he's taking up this matter.
After 2 weeks, 3 weeks. After 3 weeks. On the prayer of Mr. Ibam, London Council for the respondent. This matter after 3 weeks.
Oblige.
May I, Lordship? I would like to mention item number 6.
6.
Ah.
1.
I have informed the opposite party. So matter may be listed after 3 weeks.
3 weeks. You are Jitalo.
T. Tenzin Darge. I'm on behalf of our owners.
Okay. Mr. So-and-so, London Council appearing on behalf of Mr. Arsenal. Press for and granted 3 weeks time.
Oblige,
After
Lord.
3 weeks.
Your Lordship, I have filed an IA in respect of item number 3.
Item number 3.
Yes. I pledged,
IA.
yes, sir. The IA is for being implicated as a party in this case. I pledged
We have not issued notice in this matter.
that is so, Your Honor. But if I'm not hard to any interim is given, then I'll be affected very badly, Your Lordship.
I'm not, how do we know that this court will grant interim?
It's supposing, Your Lordship.
Then in that case, I'll pass the interim. Okay, hello. You have filed today?
Yes.
Call for the IA.
Your Lordship, I would like to mention item number 28.
28.
Yes, Your Lordship. So item may be adjourned for today, at least on 4th December. I have taken consent from the opposite parties here.
You are for petitioner?
Yes.
Appellant?
Yes, appellant.
On the prayer of Mr. So-and-so, London Council, the appellant, this matter on 4/12/2023.
Highly
Yes.
obliged.
This is close to L1, my lord.
My Lord, instruction which I received, I mistakenly left at my chamber now, it's in the way. In case of item 3, there is on the similar ground, it was rejected, ITER evaluation result.
We'll take up to some time.
Yes.
What is the stage now?
This stage, the financial bid has been already open yesterday.
It's been already
Yes.
open.
That part, Your Honor, I don't have instructions. So for this bid is concerned.
Open when? Yesterday?
Yesterday.
This bid also. Here, one of the ground
Yes,
I've
yes.
taken, my lord, that this technical evaluation report has not been even uploaded till the filing of the writ petition. And my lord has seen the reason
Have you
how
uploaded?
Yeah, detail is, all these are the
It's
detail,
uploaded or not?
this must be uploaded, this has been
Yes,
No, that
uploaded.
instruction you have to call. We'll take up to some time.
my lord,
Yes.
You take an instruction over the phone. After some time.
Okay.
You have the written instruction.
Evaluation result, entire evaluation, item wise evaluation.
You said, it's item 2 and 3 are same,
Same,
Yes, these
same
are
ground.
same ground.
Yes.
But the item 3 there is, another.
One
One
more
more
section
Sure.
so far disclosed to me.
Okay.
Yes, I have
Okay,
substantially.
we'll see. After
Yes.
some. You ask your friend to bring that.
Okay.
I think this is supplementary.
My lord, this item number
It was supposed to be.
supposed to be leased
28.
for 28.
Ah.
That's why.
It appears that there is a mistake in the order. As the matter is directed to be listed on
28.
11/20/23. Here they will list this matter on 28/11/2023. Along with that other petition,
Yes.
you just ask and give the number to her.
Tari's
Ah,
petition.
along with the writ petition number so and so. Sir, what is this? What is the matter about? You're supposed to place the relevant records. What is the matter, madam?
Yes, Your Honor. No, the petitioner was transferred from his place of posting at Jumlo Farm. This transfer order dated 14 January 2020.
Yes.
However, he was transferred from his posting place before completion of 2 years
Hmm.
in the posting place at Jumlo Farm. Hence, he had accordingly moved for a writ petition before this honorable court, and this honorable court had granted him liberty to put up a representation before the authority to let him stay in the farm until the 2 years period is over. And accordingly, he was allowed to stay in the farm. And in the meanwhile, another transfer order was passed, by which he was transferred to Geku. However, the deputy director of Jumlo Farm, he had already released the petitioner from Jumlo Farm, and he refused to release him from Jumlo to Geku, because of which he was staying at Jumlo Farm. However, he was not receiving his salary for a period of 2 years.
For a period of 2 weeks.
And there are multiple representations that he has put forth, and even the secretary and the director of horticulture has directed the deputy director Jumlo Farm to release the petitioner. However, he has completely disregarded their directions as well. And there was he was suspended.
So your basically your prayer is for
release of salary.
Release of salary of 2 weeks.
2 years,
2 years.
along with interest.
It seems like prior to that, the petitioner and the previous deputy director, deputy director had some issues, and for that, whatever has happened, it was between them. So we are yet, they are not transmitting any records of that to us.
So who is to be blamed?
So if there is record, we could proceed, but as per our affidavit, there is no record. It's just to the by the present deputy directors of Jumlo Farm. Earlier there was one who created the problem, but then he left that.
No, the person who has created the problem, if he has left, you make good of it. The present one. These are unnecessary litigation. Any proceedings against him?
Lordship,
He was initially suspended. And then however, they did not conduct the proceeding in accordance to law. He had challenged before the honorable court and now he has been reinstated and he is continuing with his service.
What is the outcome of that? Has it been concluded,
The WPCs are already disposed of.
disposed of?
He's
There's no,
already reinstated.
there's no pending, DE.
I do not know about the departmental inquiry.
You must be knowing. The
No,
fate of
about
your
the
service.
deputy director.
Okay, you are talking about deputy director.
Yes, because he was refusing to release the petitioner in this case.
Yes,
He was suspended by the department because he had not listened to
deputy
the
director.
directions. Yes, Your Honor.
deputy director. Okay,
he had not listened to the directions of the secretary as well as the director of horticulture, because of which he was suspended later on. And only after he was suspended, the current petitioner herein was released from Jumlo Farm. It was only because of his conduct that the petitioner has suffered unnecessarily here.
this court wants to see the records, how you have processed
Lordship,
about this, service, I mean, the salaries and all. Are you so helpless or what? Or
No,
are you saying that there's no records as such?
no, as per the affidavit, Lordship.
No. Are you making your submission on the basis of affidavit?
Lordship, just,
What it says?
no, this we have, that after APAR, and all, they have to be submitted by the DBA, Deputy Director.
Who you- For whom you are appearing? All the respondents. Then who has filed the affidavit saying all this?
Another is filed by respondent number 4, another by 2 and 3.
You are appearing for all. You have to sort it out among yourself.
Lordship, I may be given some time to take more instruction.
Not
Yes.
more instruction. You'll have to bring the reports.
And this matter has been pending for the last year and there's no update till now.
We'll fix next week. You, not only instruction, you bring the report and prepare the method thoroughly. Within this 2 weeks, 1 week, sir. And call the officers if necessary. And discuss with him and come up with clear instruction. Mr. I. Leonard, additional senior government advocate, pressed for and granted 1 week time so as to enable him to come with complete instruction, including the records. List after 1 week. We'll dispose it off next week.
If it may please your lordship, my lord, the respondent numbers 3, 4 and 5 have filed their counter affidavit, your lord. My lord, may kindly grant us 2 weeks time.
What is the matter, madam?
My lord, the petitioner is challenging the order of the superintendent of police.
Huh?
The petitioner is challenging the order of the superintendent issued by the superintendent of police special branch, your lordship, by which the 14 increments and increments that was granted to the petitioner was cancelled, your lordship. That is the order that,
Recovery.
yes, your lordship. No, I'm challenging the cancellation order.
Cancellation, you are granted
14 increments earlier that was
Okay.
cancelled by the superintendent of police, your lordship.
granted
Earlier,
and
your
then
lordship.
cancelled.
Yes, your lordship.
Have you been paid?
No, your lord, not yet.
Granted, but not paid.
Not yet.
Then it has
No.
been cancelled.
Yes, your lordship.
But you have taken 4 weeks time on September.
Yes, your lordship. My lord, the petitioner is attached to,
MS so and so. And Nitamuk Leonard Council appearing for this. Appearing, Leonard Council for the petitioner. And also Mr. You are appearing? Yes. And Ratar, Leonard. Additional advocate general. Mr. MS Nitamuk Leonard Council for the petition. Press for the granted 3 weeks time, 3 weeks, 2 weeks. 3 weeks time to file affidavit in reply to the counter affidavit filed by the state response. List of the three. Sir, what is this? What is to be done?
Your Lordship, this is an application under section 115 for to set aside and quash the interim order passed by the learned court below. This is pertaining to land dispute case.
Yes.
So here the land in question has been purchased
Please proceed.
the land in question has been purchased on 2nd July 1984 by one Srimati Yarifadu, purchased from one Sri Jumdokandam. And the total area is 6,017.5 square meter. So wherein during the purchase of this land in question, petitioner herein was the witness. So may I take your Lordship at page 17 and 18. Annexure A, page 17 and 18. This is the Annexure A where first the land in question was purchased by some other person. Then thereafter petitioner has purchased the said land on 25/11/1988 from Yarifadu.
Let us see the impugn order. 14/12/2020.
Now here,
Impugn order, let us see.
yes, impugn order is at page 42.
42.
So annexure H.
Relevant portion of the page 44. What has happened, if I could
Yes.
just point out, there was a cover between the petitioner and the respondent on 8/5/2021.
Yes.
That was decided in a favor, so ex parte cover decision. That was put to challenge before the learned district judge. The learned district judge, by order dated 2012/2021, allowed the appeal since it was passed ex parte. However, invoking order 41, rule 23, it was remanded back to the cover. That order has not been put to challenge, by the way. It has now attained finality. The remand back has attained finality. Now, in between, when the Kaba proceeded again in terms of the order of the learned district judge, he filed a civil suit before the learned civil judge senior division. That is why this order has been passed.
Okay.
The decision of the district court, district judge, has not been put to challenge, remanding the matter back. That order has not been enclosed, in fact, with the civil division petition.
Yes, you go back. Go back to village authority.
now.
You
my
have not
only
put to
limit-
challenge the order of the district judge.
Yes.
Now only my.
But you have
limit-
filed an appeal against the Keba decision,
Yes.
wrongly
my-
or rightly.
My only prayer is, your lordship, is that let the matter be remanded back for de novo trial. That's
By
my
whom?
own,
By whom?
by the same court. Because I have
Same
a,
court, but by whom?
by
District
the
judge, civil
yeah,
judge.
the civil judge for de novo trial.
What about those orders of London district judge
No,
remanding back to the village authority?
my prayer is that since I have been possessing the land in question for
Doesn't
30
matter. You agitate all this before the village authority.
because in the village authority, I have repeatedly submitted an application wherein I have prayed that I will not participate. Why I will not participate in the village authority? Because there is a biasness.
Okay.
Majority, 95% of the member, they are
How do,
family relatives.
how do we examine all this thing? Would that be
So therefore, this is my prayer. 95% of the member who are
your prayer
sitting in the
cannot be
Kaba,
considered.
Kaba,
Your prayer is considered and rejected.
no, lordship. My to the effect.
No, you just tell us what about that order? Not a single, district judge remanding back the matter to the village authority.
No,
You have not put to challenge.
that part.
What is that order?
I have
District
the-
judge.
They have not annexed. I have just supplied a copy. My lord, I'm sorry, that's a photocopy. Last page.
There are 21.
20.
It's simple
Yes.
boundary dispute.
Hmm.
Go back and
Lordship.
Paragraph 20.
have
I
a
may
rough and finish the matter.
I may be heard. Now,
It's a
now,
revision petition.
Yes.
Sir,
Hmm.
it's not a writ proceedings.
no,
Or appeal
herein
or something like
petitioner, herein
Would have conscious of the power,
applied for
we're
LPC
conscious
also.
of the power of this court.
No, Lordship.
It's a revision petition. Very limited scope to hear all this thing. What about this?
This
Your
is,
party to this proceedings?
this,
Yes, he is the appellant.
this is
You are
the
the
expert,
appellant and you have not annexed this also.
Yes.
this is the expert
Sir, very
order.
unfortunate.
No.
This is the expert order.
No,
Which
no,
one?
district judge.
Yes, this expert order was challenged before the district court.
District court
Yes,
and district judge has decided that the customary court should decide this matter. And it is disposed of on contest.
Yes.
On this is your appeal,
no, Lordship.
which you have not annexed in your civil revision petition. This is one ground. Anyway, we'll not take into that that far, but then since it is your own appeal, on your own appeal, order has been passed, appeal has been disposed of
Yes,
on contest.
yes.
You have not put to challenge this.
No,
Still then you are trying to, this is, sir, in view of this
no,
court,
only because of the,
in the considered view of this court, this is one of the total, abuse of process. One of the cases.
no.
Number one, you have not annexed it. It's your own appeal. And it has been disposed of on contest, your appeal. And you have not put to challenge to this.
Now my
And
only,
it has not been annexed in the present civil revision petition.
now my only submission is that since the matter was challenged, the Kava authority, the expert order was set aside and quashed, and thereafter, I have repeatedly approached the village authority. Even if there is a biasness, element of biasness prevails, but even I have approached, but the matter has been kept it for pending for.
Is it your case?
Yes,
Before this court, this present proceedings, that there is a biasness by the civil judge.
Now, present
Therefore,
grievances is there,
if
Lord.
your order has been passed, is it your case?
No, present grievances.
Are you
is-
alleging bias?
No,
Then
so present grievances.
your
is
challenge
that-
is against the order of the civil judge.
No,
Unless civil
present
judge.
grievances before this honorable court is that the learned court below has failed to exercise its vested interest, resulted in miscarriage of justice. That is number one.
What is the vested interest of the civil judge?
Then
So
Uh,
as
trial
one by
court,
one point. Let us clarify point by
The-
point.
now,
What is the vested interest? Show me.
during my appeal,
Just show me. I'll just set aside this. If you can show. Semblance of vested interest. Not the vested interest itself, semblance of vested interest. Show me. I'll set aside immediately now.
Lordship, for better
Sir, you know,
interpretation and understanding, may I read the operative portion of my petition?
operative person of your,
I would like to read out
which person?
operative portion, my paragraph. Para 13. Para 13,
Your
page 11.
operative person of your
No, my
writ petition.
paragraph, for better understanding of this.
I have understood. There's nothing.
Now,
We're not going into it's a civil revision petition. We're not going into the merit. Who is entitled, who is the owner, who is not. We're not going into that. We're concerned about the impugn order and how it came to be passed. And most importantly, you have filed an appeal
yes.
that has been disposed of on contest. You have not put to challenge that. Thereafter, you file a civil suit. Is it permissible? Sir, think over it.
No, Lord,
There may be,
I
there may be
heard.
adverse remarks. It's an abusive process of the court, law,
Lordship, now,
which this court
When-
normally doesn't want and doesn't normally do.
when my,
But if we find that if somebody has abused the process of the court, we cannot shut our eyes.
no, equally, Lordship,
You may have, you may have merit in your matter. So far as the final ownership, boundary, we're not on that. We're not commenting. The manner you have filed this writ petition, the manner you have filed a civil suit, the civil revision petition, this is something cannot be encouraged. Rather, we may pass appropriate, orders, adverse orders may be there. If we go into the merit
My-
of this petition.
my only limited prayer would be,
Do you have the knowledge? Have your client not furnished this copy?
which,
Your appeal. Just give it. Take a call. If it may happen, it happens sometimes. I'm not saying as a counsel, but counsel also need to be vigilant. At times, clients conceal the proper documents, and it's our duty as a lawyer to get all the information from the client. Have you not been given this? Share with this copy.
Lordship, my only limited.
If that is so, you should issue a notice to your client and withdraw from this
No,
case.
he's aware, my lord, he has stated in paragraph 11, only not annexed.
Okay,
Page nine.
paragraph 11.
Yes. Page 9. The petitioner begs to state that even after repeated prayer, village authority has conducted a cover in the absence of the petition and passed ex parte order, such and such. And by the said impugn order, such and such, such and such. That being agreed by the impugn, Kaba order, petitioner filed civil suit before the court of not civil suit, it should be appeal, before the district and session judge with a prayer to set aside inquest and further prayed for de novo trial. De novo trial was rejected. In down below, my lord. However, the prayer was rejected, remand back. He's aware of that. And this has not been put to challenge.
Lordship,
nothing,
may
my lord.
that, I may be
Civil
allowed time
revision.
to convince this honorable court. I may be allowed some more time.
You cannot convince. I am firm.
Lordship, I may be allowed.
I will dispose this of unnecessarily pending. Civil.
But you withdraw.
I
I
may be
can permit you to withdraw.
Yes.
Otherwise, if I dispose, hear you on merit, there definitely will be an adverse remarks, which normally I would not like to do.
I pray that I may be allowed.
Withdraw.
Allowed time.
Withdraw or dispose on merit. There's nothing. Next week. Think
Next.
about it.
My lord, Thursday is unnecessarily pending, my lord.
This Thursday.
Thursday.
Lordship, then I may be allowed with a live to press a file a press
Huh?
with a liberty.
No, liberty I cannot.
This is
I have
not a
come-
question of liberty now, because this,
Liberty,
Well, other
liberty I can give you to participate or approach the village authority as per the order of the district judge. Not only this court, in civil court below may also take a there may be remarks again. Not here only.
this order having not been challenged, there is no way out now.
There is no- Rather, it's an abuse of the process. Civil court may have may better dealt with also. So far the abuse of process is concerned.
Therefore, my only limited prayer was that since we should not allow or encourage
Yes.
the abuse of the process of the
Yes.
law. Therefore,
Yes,
let the matter be remanded back and for a de novo. Then
what do you know?
the case matter will be heard on merit before the court below. Therefore,
That
You have
They
already
pay-
your initiation and filing and all this civil suit and the filing this revision petition itself is an abusive process of the law. Are you not getting what the I'm trying to make you understand. You withdraw it or else will pass.
I may be given time.
Thursday, my lord, time for getting instruction to withdraw.
Who is in position? Position, who is in position?
I am in
That-
possession.
Therefore,
Yes.
this is more.
The land belongs to me.
You cannot be given a time. Thursday,
Thursday.
think over it.
The only
If you-
instruction he
if
can
you-
get is whether
if
to
you-
withdraw
If
or
you want
that's it.
to decide this court on merit, I'm indicating you, not only your client, the lawyers who has filed the civil suit,
Civil.
title suit,
Mm.
or lawyer who has, learned lawyer who has approached this court now. Which normally this court.
Order clearly
doesn't want to do.
indicates, my lord, after the Parwana was issued, civil suit was filed. I don't want to go into that, I'm not saying.
I avoid passing adverse remarks. But if compelled for a better administration of justice, includes the lawyers and the clients, the public at large, court has to take a call. Think about it, we'll list it for Thursday. All right. He doesn't want to before this court.
That
It's not only this court.
cannot be
It's
in
not
any
this
court.
court.
if you-
See, it's
Because
not only
What
this
I have
court.
understood, my lord, is he is
Because different court may have a different language,
Yeah.
but the law will apply the same.
Because these issues regarding the Kaba being biased and all, that is something that cannot be looked into by any court in a regional jurisdiction. And that is what my learned friend is harping upon. That is not the issue. The order of the district judge having attained finality, there is no question of any civil suit now.
The process we are saying, the merit, there may be bias, may not be
Yes,
bias.
may not.
We cannot go into it.
Now,
On the prayer of Mr. D, was learned counsel for the petitioner, list this matter on, when it is Thursday?
Thursday, madam.
22.
Obliged.
23/11/2023. Think about it and come back.
Obliged.
Be fair and frank. You are a senior lawyer now. Sir, you should support the cause of the administration of justice, not individual one case. Just you recap.
My lord. My lord, pursuant to the NIT, my lord, dated 28/9/2023, my lord, calling for my lord, electronic tendering system, my lord, under PMGSY. The petitioner participated by uploading the, my lord, tender, be document online, my lord.
Yes.
So, my lord, as per the deadline, my lord, 13/10/2023, it was a date for the opening of the technical bid, my lord. On my lord, but thereafter what happened, my lord, as per the clauses, guidelines provided under the SBD, my lord, this technical bid has to be open within 5 days from the date of the, my lord, submission of the bid, my lord. But in this case, my lord,
That will not consider,
My-
because you have come before, approach this court after rejection of your bid.
my lord. Now,
That
okay,
you didn't
my
come.
lord. Then, my lord, on
Yes.
14/11/2023, after almost a month, my lord, no, this evaluation report has been uploaded, but by email letter dated 14/11/2023.
When it was open?
On 13,
13/11,
13,
10,
11, my lord,
13/11.
13/11.
Obviously, after that only you will be intimated. Next day you have been intimated.
Intimated, my lord will see the nature of the manner in which, but requirement is that it has to be uploaded. Now, my lord, okay, even if it is intimated, somehow I have been
Uploaded or offloaded?
it has to be uploaded.
Uploaded.
Not done by, but I am not having grievances whether uploaded. I only one where by way of any means, my lord, you give me the reason. Only that much. I am not concerned whether you have uploaded, not uploaded. But as of to the best knowledge, my lord, till the date of filing this writ petition, that was not uploaded. But my lord, communication was sent to me, my lord. Kindly turn to page number 17, my lord.
17.
17, my lord. My lord, I'll just read, my lord. Last paragraph, my lord. You are informed that your bid for the above tender has been rejected during technical evaluation by the duly constituted committee for the reason clause 12.1 part 1 of section 2 ITB and section 6, my lord. This particular, my lord, requirement, my lord, yesterday, my lord, I have shown, my lord, that I have fully complied, my lord. The requirement, my lord, as per the SBD, my lord, and I have,
Form is page 67
my lord,
and your document is page 69.
page 69, my lord, then this requirement as per this SBD is, my lord, page 67, my lord. 67 and 68, my lord.
67 is the form.
My lord, form is the format, my lord. So I have to give this format, my lord. So for the requirement of the SBD, my lord. After it, my lord, I have fully complied. This has been uploaded, my lord. Even confirmation letter I have with me, I have enclosed here. This has been confirmed by the department. Yes, you have uploaded this particular document, my lord. So now, my lord, there is no other reason assigned to me. Now they are saying the ETC, my lord. Now, my lord, with ETC, my lord, even my lord will see what they have said is the only section. Now they have to say, my lord, I have submitted this document. Is there any error? If the error, what is the error, my lord? Well, how I will come to know? Now they have only just quoted the section clause, but this has substantially complied, my lord. my lord can see the reason in the,
Okay,
My lord, he was informed about the rejection of the heat bids on portent. And he have every right to access the detailed bids evaluation. He can obtain it. He have
but
not,
he said it was not uploaded.
he was informed about the rejection on portent. He has no, he knows that his bid has been rejected because of that he has come before this court. And he have every right to access these documents.
What is the documents?
This is the detailed evaluation, item wise. On which ground he has been rejected. This he could access and he can obtain.
Where's the ground of rejection?
That red mark or some mark,
Huh?
I
Have you-
make
have
it
you marked
round.
it?
Yes. There are so many grounds. Even some documents which they submitted on verification, it is not up to date. All this, there are so many grounds.
This is against the petitioner only.
Yes.
Your part one.
Yes, petitioner. So individual firms document is detailedly checked, evaluated by the committee.
That's the reason, etc. Not only close 12.
my lord. So is
Let
this
us
the
accept-
manner, my lord?
Let us accept that your close 12 you have complied with. Not substantial, not only substantial, you have complied, fully complied.
Fully, my lord.
But there is a etc. Therefore, there is so many grounds which you have been rejected.
So, my lord, whether it is rejected or
This is just an intimation. That's why etc.
My
The detail is here.
my lord,
Yes.
whether, my lord, they have a
So we'll ask them to file an affidavit.
affidavit, my lord.
No stay. Because your
My lord, is
grounds
this
of
manner,
rejection.
if this manner is allowed, my lord, what will happen? My lord, is this something you will first intimate in ETC? I know, my lord, how can I procure the document? It will take another 1 week, 2 weeks. Then after that, if I approach this honorable court, they'll say, now, it's over, what you were doing later on. How I will, my lord, secure my right? If, my lord, after complied fully, and my lord knows, my lord, how much hardship we have to put
No,
to
no, you
participate
said,
in the
you
process.
said, they have said, clause 12, section 6,
My lord.
etc.
Is this the way, my lord?
This etc. has got a proposed.
Propose. My lord, that's why I'm putting, this is the way, my lord, order, my lord, will justify, my lord,
It's
such
just-
order.
So for that, this court is of the view, it's just an
My
aberration.
lord, it is something behind my back, will reject it first. Then when I file petition,
So
they will come with
so-
the reasoning, my
So
lord.
as the provision in the ITBP, when it provides the manner of intimation,
My lord. It is there, my lord, uploaded, it has to be uploaded.
they said it has been uploaded.
My lord,
Summary of this
My lord-
evaluation has
my
been
lord,
uploaded.
if it is
Not
uploaded,
this summary.
Summary.
Yes, then he can obtain this.
What is the summary?
Summary is this one.
my lord, otherwise if it is uploaded, why should I come with this one only?
Otherwise also, my lord,
I will come with
And-
all document, my lord, that, my lord, I have already in my other writ
You
petition.
have come because your bid has been rejected.
My lord,
yes.
in my other writ petition, I have annexed all the documents, my lord. This order itself, my lord, email itself shows, my lord, the fairness, my lord, transparency. At least, my lord. Let them come with, my lord, affidavit, my lord. Let them say, my lord, what are the defects, my lord. As of now, not intimated. Now, my lord, they have intimated, my lord. As of now, I don't know.
Intimated and this court is satisfied.
My lord, always, my lord.
Prima facie,
But, my lord, don't I have the right to know, my lord?
you'll be provided.
After, my lord, then that's why, my
You
lord.
provide one.
Even annexure 7 format is not,
It's not a secret document.
not secret. He can obtain.
can
Yes,
provide.
he can obtain.
You provide one copy.
Yeah, no, I have to get Xerox.
Can you?
Yes,
Is it so sacrosanct?
Not sacred.
My
It's
lord.
He can
sacrosanct.
obtain.
It's sacrosanct, but it's not secret.
No, it's not that, it's not beyond his reach or beyond his obtain. He can
My lord,
obtain.
but provide him.
Even
That-
Annexure
that-
7
that's
is
true.
not as per format.
Huh?
Annexure 7.
No, that is as per format. I'm
In
satisfied that.
format is otherwise.
Where's the, he has given the format 67, page 67.
Page 69.
Format is page 67, 69 is his documents,
Format, let me take.
fill documents, fill format.
Then, my lord, what will happen, my lord? I will not have even opportunity so that I have complied.
Show me that.
Yes, this.
My lord,
The manner and the procedure of communication or intimation,
my lord,
just show me that.
my lord, my lord. The procedure SBD, my lord, will find. My lord, this SBD, my lord.
It's not annexed.
This particular portion, my lord, this, my lord, he's saying, my lord, within 5 days. Thereafter, I will get opportunity to file the appeal also, my lord.
Yes, result of the notification, evaluation,
My lord.
not the evaluation itself.
But thereafter is there, my lord.
No, that's
Evaluation has
the
to be
result
there.
of the evaluation of part one of the bids shall be made public on e-procurement.
My lord, I am, my lord,
Following
not
which
even
there will
for
be-
the public issue. Only the thing that, my lord.
Because
Before-
it was open on 13 and you have results were
I
published
am not saying, my lord, in which
On
way you
14th
communicate me.
within five days you can
Well, I am not
make
on
a
that
complaint.
I am on the point, my lord. The grounds assigned to me is only 12.1. I have demonstrated before this honorable,
Including etc.
etc. My lord. Then, my lord, how I will justify?
They don't have the time. So they have gone for shortcut.
But my lord,
Because there's so
my
many,
lord,
so many clauses you
understand, my
you
lord.
have not complied with.
But my lord, for their not having time, my lord, my fundamental right, my lord will look into, my lord, that if
Sir.
we say, then my lord, my
Sir, there is no fundamental right to
fairness, my
contract
lord,
with this state.
I have the, at least fair treatment is required to be given to me also. My lord,
Reference-
my lord will see how I will defend, my lord. If you say the extra is the reason,
Call allocation case.
my lord, at least,
No fundamental right to have a.
my lord, I have a fair, my lord is fully aware of fair treatment is a part of Article 41. I don't need to make argument on that part, my lord. My lord, at
Okay,
least,
we'll allow them, they will permit, will.
my lord, let them file affidavit, my lord. I will, so my lord, I have complied fully, my lord.
Learned counsel to the petitioner. Anything else?
My lord, till, my lord, that, my lord, finalize may not be done.
No. We'll consider before final issue. It may take 1 month.
Yes, there is other remedies also. He can
Go to civil court.
civil court.
What we call that, in the Food Corporation India's case. Okay, anyway. But Mr. So-and-so, huh? By filing this writ petition, the petitioner has challenged the impute email dated 14/11/2023, by which the bid of the petitioner has been rejected. on the ground that clause 12.1, part 1 of section 2 of ITB and section 6, etc. have not been complied on non-compliance of the requirements of clause 12.1, part 1 of section 22 of ITB and section 6, etc. Mr. Arsenal learned counsel to the petitioner submits that the impugn order only conveys the rejection without there being any reason for such rejection. He submits that the reasons, the evaluation result as well as result of the evaluation has not been uploaded in the website. He also submits that in pursuant to the NIT dated 29/9,
Twenty-eight nine.
28/9/2023. He has submitted his bid along with all the required documents. Therefore, the rejection without communicating with the grounds of rejection is not sustainable. Mr. Jitar, learned counsel for the learned standing counsel for the state, the rural department, rural works department. By placing the copy of the technical bid evaluation and the summary of bid evaluation report submits that after the opening of the bid of the bids of all the bidders, a proper evaluation has been made by the authority, whereby the bid of the technical bid of the not only the technical bid of the petitioner is found to be non-responsive for non-compliance of section 12, clause 12.1 of the ITB, but also there are other grounds. There are other clauses where the bid of the petitioner is found to be non-responsive. He submits that the summary of the bid has been uploaded, for which the petitioner can very well obtain the same issue notice returnable within 3 weeks. The petitioner, the London Council, London Standing Council messages that is directed to file affidavit in position within 2 weeks. Thereafter, the petitioner may file his response to the within another within a week. So that after 3 weeks, this can be
Finalize may kindly. Otherwise, my lord knows, my lord, I don't know why at least, my lord, I should have that right at least. I have entire document, my lord. at least give me opportunity to satisfy my lord that I have complied, my, at least. I'm not asking, I know the limitation, my lord.
Finalization of the tender process, tender in question is subject to outcome of the request. It's okay.
Give you.
It's always.
It's
outcome.
always-
Same, similar.
order. But this is the different.
Different.
Different package.
Package.
You just take with the package number is given. Just
Package number, this one is AR060269. And one more section will be there. Clause.
clause,
Clause,
13 point.
my lord, one more clause is there. 1.2 of section 3.
1.2 of section 2.
Then again, extra, my lord, here also.
In the summary, it's
All are extra, my lord.
in the summary, so many.
In a way, they are correct. Shortcut. Why to unnecessary lose the ink and paper?
Yes.
But they will give, my lord, more burden to the my lord. My lord will be have to analyze all the thing, my lord.
That burden this court is satisfied.
Deeply on that.
My lord, that document, let me get Xerox and give back to the court.
Huh?
I'll get it Xerox.
No, I'll just I'll return it.
Ah,
Return.
May I plead, my lord?
Yes.
Item. This matter relates to compensation of horticulture,
Can I take up?
agriculture.
Is it not that this is yes pertains to only Matnagar Road? Can I take up or not?
Respondent number 7 and I think so. I think it can be taken up.
Respondent, who is the respondent number 6?
Respondent number 6 is the additional deputy commissioner.
Yes, well, the affidavit.
5 and 6
They
we
have
have
filed.
filed, your lordship.
And
5 and
they-
6 we have filed, your lordship, for DC and
So
additional.
others,
Others, yes.
you don't want to file.
Yes, the affidavit filed by 5/6 will go by my case also. But affidavit from the.
Central government.
Yes, it will be required.
Where is
Central government, yes.
Learned Deputy Solicitor General, where it is, where he is.
I think he is not present. His junior was present in the morning.
You want to file a reply or you want to argue the matter?
Let CGC file the reply, counter affidavit. Madam.
Okay. Heard Mr. Esmo, learned counsel for the petitioner. And also heard. Who is first? You are for state respondent.
Yes, 5
Yeah,
and 6, 5 and 6.
He is for
I am for
3 and 4. Okay.
3 and 4, yes.
Union is 1 and 2.
1, 2 and 7.
Non-APS for respondent number 1, 2.
1,
5,
2 and 7.
1, 2 and 7.
Let them file
Mr.
the
D.
affidavit.
Kapil for 3 and 4, and MSD Arbasar for State Council for 5 and 6.
Yes.
Must MS Arbasar State Council has submitted that she has already filed a counter affidavit. Mr. D. Kapil submits that he will rely on the affidavit filed by the state respondent. Mr. S. Learned Counsel for the petition submits that the affidavit in opposition of the respondent number 1 and 2, 1, 2 and 7.
7.
Would be required.
Yes, to file.
List this matter after
2 weeks.
4 weeks.
4 weeks.
4 weeks. So as to enable the Learned Counsel for the Union of India by affidavit in opposition.
All right.
Give me please, your lordship. My lord, the respondent number 3 has filed a counter affidavit, your lordship. My lord,
These are not yet filed.
yes, your lordship. My
Huh?
lord, yes, your lordship. We are yet to.
MSD Tamil London Council for the petitioner submits that she may be granted 3 weeks time
Yes, your
to
lordship.
file affidavit in reply. Praise the Lord. MSD London State Council present. Praise the Lord. This after 3 weeks.
Much obliged.
Even in this case, my lord, I will require some time, my lord, to file affidavit in reply.
Reply.
Yes.
Mr. D. P. London Council for the petitioner has pressed for and granted 3 weeks time to file affidavit in reply. Mr. I. Did London additional senior government present.
Interim order may be continued.
Interim order was earlier will continue.
Obliged.
Lordship, this must be passed over for a time being, lordship. My senior,
Any affidavit?
Affidavit, my lord, the standing council education, he is supposed to file the affidavit.
Where he is?
Today he is not available. In fact, I have been told by him that department proceedings against this petitioner is underway. Going on.
So this is against what?
Suspension, this is for revocation of suspension.
lordship, here, lordship, after-
Review.
No,
No
not review, lordship.
No review
Yes,
within,
lordship. Oh,
within 90 days.
Yes, lordship. Yes,
No, my
lordship.
lord,
In
here,
my case, this is, and this is deemed suspension case, lordship.
my lord, if I'm correctly means with the facts, correct with the facts, they have already been given the charge memo.
No, charge is already there.
Charge
We
memo,
are not on the charge, lordship.
now,
No,
as
no, if charge is already submitted, what is there?
and there is an amendment to the rules, my lord.
Lordship.
19/11/2022.
Amendment is also in my favor. lordship.
We did affidavit.
Lordship, instruction may be sought, lordship, otherwise, lordship.
Otherwise,
I was
No,
going
but then somebody has to appear on his behalf to
Yes.
make a mention.
On behalf.
Just because
Yes,
he's,
Lordship.
he's absent, so we'll adjourn it.
Lordship, we are yet to receive instruction from the department, Lordship,
Okay.
to file affidavit of opposition.
How many weeks or months,
Lordship,
do you need for instruction?
Lordship, 3 weeks may be given. Lordship.
no, lordship. I'm going to return on next year, lordship.
It's okay, you'll get all consequential benefits.
Yes, lordship. No, even the lordship, at least within service, lordship, at least I have to exit gracefully, lordship. Before it.
No, we need affidavit. We'll have to see what is the state.
And lordship, otherwise, lordship, record may be called, lordship. Record may be
I-
called, lordship.
record of the departmental proceeding, whether that,
Not record, lordship, record of the review, lordship, whether they are review.
Now let them file affidavit, it's a 2023 matter, all right?
Lordship, then
But
lordship,
Mr.
fix the matter, lordship. When they are lordship, if even time lordship, though lordship, fix the matter, lordship, and treat it as urgent, lordship.
3 weeks.
Lordship, I am appearing for other two matters, Lordship,
Ah.
Gomosora and Opet Mubang, Lordship.
What about these two other matters? It's
Lordship,
also-
Gomosora, we have received the affidavit in opposition, Lordship.
Okay.
But then I feel that as per their record, they say that they have extended the suspension period. But I don't find any report of the review committee, Lordship. If they are willing to file that, Lordship, it would be good, Lordship. Otherwise,
You said you have extended
yes,
within the stipulated.
Yes, madam.
period. So
Here.
Bring that.
yes, my lord, here,
Report of the committee.
yes, my lord, here,
they have not annexed the report of the review committee, Lordship. They have just annexed the order of the extended
Do you have the
suspension
record?
period, Lord.
No, review, the extension order is, we have annexed, my lord.
He said,
Lordship, it is
We have
mandatory, Lordship.
No, we have
for-
annexed the extension orders. That has been done within the stipulated time.
So why, Lordship, I'm
so matter.
the
become
report of the
in
review
process.
committee is mandatory for reviewing and extending the suspension period.
Obviously.
That is mandate of the law,
Obviously,
Lordship.
after the review only, the order will be
Yes,
passed
after the review,
for extension.
the order.
But then
itself
I don't
reflects-
find
Not,
it
not
that,
without any review.
Lordship, exactly, Lordship. So why, Lordship, that review committee's report, they have not annexed, Lordship. That would be required for
We'll call
proper adjudication of this court, Lordship. So why record may be called for, Lordship.
For,
Is it landed additional, we'll call for the. you-
yes,
you bring the-
review, if, review committee's report is required, that which we have not annexed. that-
You bring the record.
Mm.
Okay.
Yes, sir.
And what about this item 3?
Lordship, item 3,
13.
Lordship, Opet Vibhag, Lordship,
I-
Is
that
also
also
same.
Education department, my lord.
Education department.
Education Department. So, Lordship, ground is almost same only, Lordship.
So. Or Mr. G. Bam. And Mr. J. G. Nick, learn counsel for the petitioners. You are for 12 and 13. And then you write in the first 11, huh? Or Mr. G. Bam, learn counsel for the petition. And also Mr. N. Rathan, learned additional advocate general for the state. Mr. K. Tabang, learned counsel appearing for Mr. T. Jam, learned standing counsel, education department. Submits that he is yet to receive the instruction for filing affidavit in opposition, for which he prays for 3 weeks time. Where is allowed? List this matter after 3 weeks. Then item 12 and 13, J. Gini. Why 14 is so auspicious? It's 14 is after 3 weeks only. At least a matter on 14/12/2020. Then in item 12 and 13, J. Gini, same order. Sorry, item 12, J. Gini and N. Rathan. The Mr. N. Rathan submits additional submits that he has already filed the affidavit of opposition. However, the review, the report of the review committee has not been annexed. The learned addition is directed to place the reports of the review committee. Review committee or
Review committee.
authority? Review committee.
Lordship,
Is it review committee?
It's a competent authority.
Lordship, review committee. Review committee, it's called review committee.
In the order, it reflects about competent authority.
Competent authority, he can pass the order, but then it has to get the instruction from the review committee, Lordship.
In that case, we'll say the learned additional AG is directed to place the record.
Okay.
Lordship, and item number 13, Lordship.
Item number 13.
Last
J.
of-
Gini, and same prayer in the in item number Mr. So and so on behalf of T. Jama. Same prayer.
Lordship, small prayer.
This
Last
three
occasion
cases
also I
will be
have,
listed on 14.
Lordship, item number 13, last occasion I have made a small prayer regarding payment of my subsistence allowances, Lordship.
You file a petition.
Lordship, in fact, I have made a small prayer in the interim, Lordship.
Where?
In my writ petition 510, Lordship.
You are working as what?
Lordship, I am working as UDC, Lordship, under the office of DDSC Inkyong, Lordship. Page 14 is in the interim, Lordship. I have sought for
Mr. After that, after recording all that, Mr. J. Gini, learned counsel for the petitioner, submits that an appropriate order may be passed for providing subsistence allowance to the petition. I'm considering the submission of the Madam Council to the petitioner. It is expected that the respondent authorities shall provide subsistence allowance to the petitioner forthwith, as it is the due entitlement of the petitioner under the law, under the rules.
Much.
In your matter, first let them file a affidavit. Let them file opinions.
This matter may be.
List before any other appropriate bench. Without me. What is to be done today?
My lord, here, my lord, as on today, my lord, this security amount, my lord, which is mandatory, my lord, that has not been deposited. Let the applicant deposit that amount. Thereafter, my lord, matter can be listed for admission, my lord. Order 41, my lord, it is mandatory, my lord. When the money degree is concerned, my lord.
What do you say?
Lordship,
your colleague is, Mrs. Sonar has been pressing her since the day one. Order 41.
yes. On previous occasion, same issues was also raised, but this honorable court was not considered it as the mandatory.
Has it been admitted? No.
Not yet. Well, order 41, my
You
lord.
deposit and in that only on deposit we can admit it, please. Not otherwise.
I'm reading, Your Honor, Rule 5 of sub-clause 5. There are also some provisions. The deposition will be mandatory only when there is a prayer for stay of the execution or of the decree.
You're reading that section is not applicable so far appeal is concerned. I think he has to read order 41, rule 1, sub rule 3, not that 5.
Yours is?
Your Honor,
Yours is which provision?
Order 41 and Rule 5, sub Rule 5. Stay by affiliate court.
No.
So execution, unless there is a stay, execution is not barred.
My lord.
Will not be stayed.
Yes.
So you may proceed with execution. without
Execution, I will
deposition.
proceed, my lord, but so far.
But will not admit this because for orders will not admit because he has not prayed for admission.
My lord. Then, my lord,
In case of admission only, will ask for to deposit the security. But if there is no stay, and he is not seeking for stay also, you can proceed with the execution.
My lord, here, my lord has written. So far, my lord, the section which is referred by my friend, This is
In case of stay.
that is in case of order stay by the court
Yes.
which passed the degree,
Yes.
not by the appellate court. So far, my lord, kindly try to face this order 41.
No, that's what I'm exactly saying. You may proceed with the execution.
I will.
There's no stay. Is there stay?
No. But my lord, when appeal is filed, my lord.
So
he has to-
we'll on heard Mr. So-and-so, both KL and London Council for that, and also Mr. Arsenal, London Council for that. Respondent
My lord, I'm sorry.
only,
Yes.
sole respondent.
Sole respondent.
List this matter for admission hearing. On that, you may argue. You may say that it cannot be
Admitted.
admitted
my lord.
because
Okay,
he
no.
has not deposited.
Right.
He may say that it should be admitted without deposit because he can proceed with the
My lord.
execution.
My lord.
Duly applied.
Mr. Nibo, what is this? What is the matter? Okay. Heard Mr. M. Nibo, London Council for the petition, and also heard Mr. Who is number one, serially? Who is appearing for number one?
Petition number.
I. Ram, Senior Edition, Learned Senior Edition, Government Advocate, Mr. D. Kamlik for Eastern Council for Land Management.
One,
Department. You are for?
Respondent number 5.
Respondent number 5, Odugo. Office note dated 20/11/23 reflects that no affidavit of opposition has been filed as on date. Affidavit has been filed on behalf of respondent number 1 and 2. You are one on.
Lordship, Lordship, it's on process, Lordship.
Mr. I. Learned Edison Senior Government submits that he's on the process of filing the Edison affidavit in opposition, for which he seeks 1 week time or 2 weeks.
2 weeks. 2 weeks.
2 weeks. Is there stay? Then in that case, 3 weeks. Interim order first and the second.
Respondent number 5 is filed.
Mr. Odugang London Council for has submitted. He has already filed his contrary affidavit. Okay.
My lord, my friend who is appearing for the private respondent, he has been seeking time on many occasions for filing of affidavit, but till today he could not file affidavit. And my lord, even if this matter is fixed for hearing also, only the outcome would be that this matter will be remanded back to the deputy commissioner.
Are we sure?
Yes.
So we'll remand it today.
Yes, that will be my prayer.
On the, we'll just write 2-line order. Heard Mr. So-and-so, so-and-so. Do you agree?
Yes.
The London Council for petitioner. And also Mr. I. London Admission Senior Government for state respondents. And Mr.
I am for respondent number 3 and 4.
Mr.
Ex-Giati.
Ex-Giati. London Council for respondent number, appearing for respondent number 3.
3 and 4.
3 and 4. Next para. On the consent of the parties, without going into the merit of the matter. No, on the, in view of the nature of the prayer made in this petition, and without going into the merit of the matter, correct?
Yes.
And as agreed to by the London Council for the parties, this petition is disposed of. Remanding the matter back to the
Deputy Commissioner.
Deputy Commissioner. Which district?
This Capital Complex.
Capital Complex.
ICR.
For what? What is?
For adjudication of the matter.
Huh?
For adjudication of the matter.
What is the matter?
Matter is regarding LPC.
For adjudication of the dispute regarding the.
Yeah,
land
sorry for
possession.
interruption. Since before also the petitioner, he approached the deputy commissioner in respect of same subject matter. Then deputy commissioner referred to the civil judge trial court. Then again, the
Then
petitioner.
we'll have to hear on matter.
Then let me, I'll submit.
If
this.
I could
Then-
have been agreed
then-
that this should not be remand back. They have,
Have you filed the counter affidavit?
not yet.
You file. We'll give one last chance. Then in that case, if he is not agreeing, can we remand him?
In certain case, I agree. Remand that I don't agree, but he has every right to approach the deputy commissioner.
And then you delete all this thing, you remain all the.
Then let me
arts and
submit-
so, arts and so and so. The learned counsel for the respondents. There are, sorry, respondents are directed to file their counter affidavit within 2 weeks. This case has been adjourned as a last chance for filing counter affidavit on behalf of all the respondents.
No, Lordship, we have filed.
You have filed for respondent 3 and 4, sorry, in that case. What is the status here?
No,
No counter affidavit.
we have filed, Lordship.
Huh?
We have filed.
None appears on call. Mr. I read up, then additional senior government advocate submits that he has already filed the file his affidavit in opposition on behalf of respondent so and so so and so. Mr. Office note dated 20/11/23 reflects that affidavit in opposition has.
3, 4, 5.
Filed on behalf of respondent 2 and 6 to 9. List this matter after 3 weeks so as to file, so as to enable the parties to exchange affidavits. For a petition. And for this record, you say, Mr. Jiriba. Not the concept of petition. You delete that non-application, huh?
My lord, respondent number 4 is yet to file their counter affidavit.
Respondent number 4.
Yes. And for the respondent.
What do you want today?
Some more time.
For MS determined for petitioner, Mr. MS K. Wang for Lorry District Council for State Respondents, Mr. B. Ori for B. Ori, London Council appearing on behalf of respondent number 4. Press for and granted 3 weeks time to file contract. List up to 3.
I'm the petitioner here. I received the affidavit filed by the respondent. I may be able to file here, reply in the Congress.
Mr. B. Ori, Learned Counsel for the petitioner submits that he has received the counter affidavit filed by the respondent. All the respondents.
Yes. One.
1 to 5, you want.
1 to 5. You are
Yes.
appearing.
Yes.
Mr. B. Ori submits that he may be allowed 2 weeks time to file reply. There is a lot. List after 2 weeks. Mr. So and so appears for respondent number 1 to 5.
1 to 5.
1 to 5.
Yes.
Right.
I'm from the respondent, sole respondent.
Yes.
That's why I have filed with the affidavit of opposition.
You have filed it.
Yes,
So
so.
list it for admission hearing.
Yes, admission.
heard Mr. So-and-so, learned counsel appears. Learned counsel appears for respondent, petitioner, and Mr. So-and-so for sole respondent.
Yes, sir.
Only one respondent.
Yes.
Sole respondent. List is matter for admission here. After 2 weeks, 3 weeks.
2 weeks, 2 weeks.
2 weeks.
Hello.
Chief, Chief, I'd like to mention in item number 24, the BK Singh has directed me to apply this honorable court, stating that the matter was supposed to be listed on 21 December of this year. But it was wrongly listed today, Your Lordship.
Okay.
So matter is fixed on 21 December.
Mr. Your name?
M. Tangai, Lordship. As per instruction from Lordship.
Mr. So-and-so,
BK Singh.
appearing on behalf of BKC. Says that matter may be listed on
21
21
December.
21/12/2023. MS so-and-so appears. You are for?
Hello.
No. You are for?
I number 94, Malad. Respondent number 1.
Okay, on.
And the petition has not served any extra copies, madam. So we could.
No extra copy.
Yes.
I'm for the petitioner.
You have not served.
Yes, today it is to serve today.
Huh?
Serve today.
You have served.
No, today I will.
He will serve today.
The same process is going on. Without extra copies, you don't take instruction. Which I Mr. Whatever 629 service report. MS. Learned State Council submits that the petitioner has not is yet to serve extra copies for which he could not obtain necessary instruction. Mr. So-and-so learned counsel for the petitioner.
Yes, madam.
Press court. When you will furnish today?
Yes, promise.
The Mr. So-and-so learned counsel for the petitioner submits that he may be allowed to furnish the extra copies.
Yes.
During the course of the day. The learning counsel for petitioner is directed to furnish the extra copies to the state respondents during the course of the day. Then you are appearing for
Respondent number 5, my lord.
Mr. So-and-so appears for respondent. You don't want to file any affidavit.
You will file, my lord.
Respondent, learning counsel for the respondent number 5. May file is affidavit in the position. Office note dated 20/11/23 reflects that the service of respondent number, service report in respect of respondent number 629 is still away. This matter after 3 weeks.
Nice.
Lordship, the leading counsel in this present case, he will be joining your Lordship by virtual mode.
Okay. But before that, we have passed a similar order.
This is the same case in division bench, lordship was there. They have been directed to sit there, and we have been directed to provide the basic amenities like electricity and water. We have already provided.
Same matter.
Same matter, and they went to Supreme Court. And Honorable Supreme Court said that, okay, you have to sit, but timeline has been extended till 31st of October.
Then why?
Now they have, one order has been passed by the Deputy Commissioner. For another quarter, they have been shifted to rented house. And that rent has to be provided by the municipal. And now by filing this writ petition, they are asking for the same benefits.
What should be done in that?
On the basis of the order passed by this Honorable Court, Division Bench, and Honorable Supreme Court. This writ petition itself is not maintainable. Because law is state lordship, either lordship the accommodations, if that's available, or HRA. This is the law lordship. By way of deviation from that lordship, if any benefit is provided to some person.
It's okay that I have understood, but can this court take up this matter? Because we will have the same view. There cannot be another view.
Lordship, if we refer the last.
What is your prayer?
We are asking the similar benefits which they have given to the other party, each sector party, which has been elected by the authority. We are asking the same, not a same benefits only we are, not any more thing. Because we are also government employee, they are also government employee, same category. By order of this Honorable Court, last occasion, clearly mentioned that directed them to file affidavit or either to get specific direction in what, which criteria the order has been passed. That was the last order.
Let us see the order.
Order dated, Lordship, 8 November 2023. Last order.
Which page?
No, last order. This Honorable Court's last order.
No, I want the impugn order.
Page 116. 116. A.
116.
A. It's type copy. It's 8 page 116.
This is the benefits which has been given to the other party. We are asking
so you
the
are
same.
Seeking a similar relief.
Yes.
A similar the
benefits.
Benefit this thing.
That much only we are asking.
So extend them. What's there?
Lordship, we have already provided them the accommodation. And this Honorable Court has directed them to sit there.
Then
Lordship.
Then they, instead of shifting their lordship, they are asking for this benefits lordship.
Lordship, let them come with the affidavit since because they have
this court has already considered the division bench.
Yes, even the Supreme Court.
They directed you to shift there where you have been given the accommodation. Correct?
That was
Just as well.
Yes.
Correct. Now you don't want to shift there. You want the same benefits as given to these people.
Yes.
Yes. That cannot be your choice.
That was in eviction petition. Now this is completely different. We are asking under the equal benefits under the section of 14, Article 14 of the Constitution. We have to be treated equally. That's why we are approaching. That was in the eviction petition.
Where do you
Anyhow,
want
Lordship, may I afraid that
which building you want to go?
We are asking the rent. Rent money, which has been provided to the other party. We are asking the work for 1 year they have provided to the other party.
Just tell me what is it?
The instruction I have actually. This matter is a bit different. Why? What happened in another case? Also, this Honorable Court has directed either to you to vacate the place.
That is good.
This page 116 is by the deputy commissioner.
Yes.
By the deputy.
And in those writ petition, I mean, in those cases by the housing department.
Yes, no, my lord, what, just 1 minute, I'll take. What's happened in this case is that here, the construction would be for parking place. So the people who will be shifted, they wouldn't get any alternate accommodation. Therefore, the Smart City Project Development Corporation, they said for that difficulty, we will pay their rent for 1 year. After that, it's not sure whether they will get rent or housing or not. That's the case. But in similar cases also, and other cases, they are being provided alternate accommodation. Now, whether if they want to, they say amenities are not there. We say we have provided everything. If they don't want, HRA is already there. There is not similarly situated. Because those people we don't know will ever get house or not. Here in this case, we have promised that we will give them the first priority. After
The moment you complete the.
Yes,
project.
yes.
Lordship, as the learned council has submitted it, we have been provided the alternate. We have been asked to shift at the Likki. The real situation in Likki, that building, the NDR Jawan, they are staying there.
I'm also going, this court is also going to shift to the next.
We are family members. We are having kids, children. How we can stay there together with the army
This court
Jawans?
is also not shifting.
No proper
I'll be
electrification.
shifting with my family.
No,
Lekki.
no proper electrification, no water properly. We are having a family. Therefore, we are asking the equal benefits. There should be not pick and choose. I'm also government servant. They are also government servant. Every right
My
the
lord, may I?
government-
May I, my lord? I'm for the petitioners in item number 29 only. I think that is the one going on, my lord.
Yes.
I could not join. I was just able to join, my lord.
Proceed,
But that's
proceed.
my only.
please proceed.
Well, that's my only grievance, as was brought out in the preceding order, my lord, was what is the criteria chosen by the state to differentiate between the 7 other government employees and the 17 of the petitioners. That is the crux of the matter, my lord. My lord, if they are given alternate private rented accommodation, then why can't we be given the same, my lord? We are absolutely
No,
similarly placed.
Say, difference is they are saying these are the persons whom you are claiming parity.
Please.
These are they have been shifted by the other authority. At the same time, you will be allotted the government quarters the moment the project is completed. It's for a temporary period. And if you don't if you don't agree to the accommodation, you may claim for HRA.
My lord, the grievance is Lekhi village
See,
is uninhabitable.
I'll tell you, there are so many government employees. Suppose a government employee is given a quarter at Itanagar. Can you claim that I should be given to Itanagar? You cannot.
No, absolutely
Your
not.
only right
There's
is
no.
the right to accommodation, shelter.
Please, my lord.
And if there's a dot of quarters or accommodation, you'll be entitled for HRA. If they don't provide, then you have a right.
My lord, I understand, but my lord, I'll just be very precise.
Just wait. Have you filed the affidavit?
No.
You filed an affidavit. We'll see.
But this
Next week.
Payment part, government can, because this is not provided by the housing department. This is being provided by the municipal corporation.
No,
they should have been made as a party.
Provided by the concerned department.
But that is already.
We are ready to provide it.
Yes.
No, on the
My lord-
basis of the
my lord,
order passed by this honorable court in the division bench and apex court also, whether this is maintainable or not. Allowing this means it will defeating that very judgment also. Apart from that, law, the order of 116 laws, it has been passed by the deputy commissioner, who is not competent at all, though it has been passed by the deputy commissioner of this
This
particular state.
parity, the order which they are
Yes, yes, on
Claiming
the basis of which
parity.
they are claiming the parity.
Ah.
And deputy commissioner has not been implemented his party also here in the.
Milord, they need not be made a party. They need not be made a party for the simple reason that when Article 14, the violation of Article 14 is being challenged by me,
No.
it is. Please, ma'am.
Mr. Chaudhary or what?
Sagar, Mr. Sagar.
Mr. Sagar,
Please, ma'am.
the party who has issued the order should be
Please.
made a party.
Well, it's part of the government, my lord. It's part of the state. No, my lord. When Article 14, the violation of Article 14 is challenged in a court of law, it has to be seen qua the petitioners, the employees.
Mr.
Please, my lord.
Sagar,
Please, my lord.
let us not have a lecture on the Article 14. Matter is very simple. You want a similar accommodation. This court is
Please.
not agreeable to that. You cannot have such type of fundamental right. You have a right to shelter that has been provided, and similar connected matters, this court, while sitting in a division bench, has already passed the
Please.
order. If you
Please,
have some doubt, I'll not take up this matter, but this court view is, I'm firm of our view.
My lord. My lord, the
Whatever,
division
if
bench
you
may-
don't, if you don't want to shift
Please.
to a place where you have been given the accommodation, you ask for the HRA, which is your entitlement. All right.
My lord, the HRA is, I'll be very honest with the court, my lord, the HRA is so low and the rent is so high in the place that we are residing, my lord. It will become
Well, it's-
unsustainable. Please.
See, you cannot ask for everything. It has to be as per the rules, applicable rules.
I bow down. I bow
As
down
a-
to
as
that,
a-
my
as
lord.
a- As a government servant.
Absolutely, my lord. And I am not here by choice, my lord. It's not that I'm
It's
liking
not-
the
it's not-
litigation.
It's not a case that you have not been provided with the accommodation. Accommodation, though, you have been provided.
My lord, that is for the
It's-
below
it's-
poverty.
No, it's not like, it's that you don't, it's not to your liking.
No, my lord, let the government say right now, let them say that the Lekhi village is not for below poverty line people. If it is for a particular class of people who are below poverty line,
That issue has
how
been already
can,
decided also.
yes, that is why I'm not of that.
Decided in another writ petition.
That is why I never raised it in my writ petition, my lord. I am just answering the honorable court's query that why I cannot shift to Lekhi village. I'm just answering the court's query. I'm not raising
So
this
if you-
point
if you-
again, my lord.
If you cannot shift, please ask for HRA.
Lord, the HRA is
If they don't
unsustainable.
provide, if they don't provide, then you come back.
Lordship, I'm placing one judgment. These similar lordship, ongoing another project. They have been proposed to shift it to lordship Chimpu lordship. Then this writ petition, last week only it was disposed of. Kindly come to para 6 lordship. It is a specific stand of state government response that in the past phase, a cluster of type 2 quarters at A sector Itanagar, where the petitioner are presently residing, has been approved by the government for redevelopment and employees of A sector whose quarter had been sought to be rebuilt will be accommodated in this better place with additional facilities such as parking place, common garden, and so and so. From the opposite, it is seen that the development project has been decided to taken up by the government for construction of quarter for employees like petitioner. Such project can only be halted when such action on the part of the state infringes any vested and concluded right of the petitioner. Admittedly, the petitioner are government employees, and it cannot be said that each and every employee under state are having a vested and concluded right to have quarters oblique accommodation given by their employer, inasmuch as the employees are given HRA in lieu of accommodation. It is also well settled that for the issuance of the writ petition, existence of vested and concluded oblique legal right is a sine qua non. This court is of the considered opinion that being a government employee, the petitioner shall have no vested and concluded right to continue to stay in the quarters, which the government is proposing to demolish and rebuild quarters led to in a given extent of the government, that those quarters are being made for employees, including the petitioner. In view of so and so, the case has been dismissed. And why I'm pointing out, Lordship, yes, these present petitioners, they have been proposed to be shifted at Lekki. And this particular petitioner, the judgment, they are proposed to be shifted at Itanagar Chimpu, Lordship.
Yes.
And petitioners have not been singled out for purpose of discrimination, Lordship. We are, as per the availability of the accommodation infrastructure, accommodation, Lordship, we are shifting not only the petitioners, others also. In other area, Lordship, we are shifting them. And one of them is the present citation, the case which I'm placing. So what I'm submitting is, Lordship, this is not the only the petitioners who have been shifted to the available government accommodations and rest have been accommodated in a rented house. That is not the case. Since 2-3 cases, Lordship, we have shifted them to the available accommodation, government accommodations. And when we found that, Lordship, accommodations are not available now, government accommodation laws. So we are ready to pay the HRA, Lordship.
And I've had no time to review this document. This document
is judgment of this annual court.
I would like to have this judgment, and my lord may take it up next week or after 10 days, my lord.
What about these orders, 811? 811 orders.
811.
You are supposed to file
affidavit in opposition or either specific
or bring any instruction.
specific
Yes, that I have brought.
criteria.
Criteria.
That I brought.
Now, why this?
I have provided, yes.
This instruction.
Yes.
Criteria has not been provided here.
Malad,
Criteria has not been provided here. But
Malad-
the instruction.
Malad, because it doesn't come under us. Malad.
So
It
you can say
No,
what is the criteria?
Yes, it is the Smart City Development Corporation, which is providing the 1 month rent to them. It's not the government.
To them.
Yes, to the other party.
the other party.
Yes, in case of smart parking lot construction.
What about this?
In
Malad,
our
it's
case also,
totally different. Malad, totally different. That's-
multi-story are going to be constructed in my place.
Yes, parking lot.
That purpose, multi-story building are going to construct.
You by demolishing the government quarter.
Yes. It has already.
Okay,
same nature.
how can you be objected to that?
That's why we are not
And
objecting. We
it's
are asking for same benefits.
And they
that
are
much only.
constructing it for you. And during the construction only, you have been given the alternative.
Therefore, for 1 year only, we are also asking. 1 year, which they have been given to the other party, only for the 1 year.
Supreme Court, how much days?
38 October. Oh, it's
And
over.
they have been directed to furnish undertaking before the Honorable High Court.
It was given.
Given. They have given undertaking also. They'll shifting by 31st October and they have not.
The same petitioner.
No. The same petitioner.
Yes.
This is the same case. Those.
Mr. Sagar, please.
Please, my lord.
Will dismiss. There's nothing.
It is liable to be
You have
dismissed
asked from the
forcefully.
Supreme Court a further time, right?
No, my lord.
And then
My lord, the
you have
reason
taken, you have given an undertaking.
I have.
You cannot
I
have this,
Our-
agitate the same thing again and again.
No, my lord, this is with very respectfully, my lord. This is not the same thing that we are agitating. My lord may have my writ petition. I have specifically written
Not-
that I'm not trying to-
Basically, what you want? You want the
My lord,
accommodation.
I want
like
an
that of
accommodation.
Other person that can be distinguished.
They are not able to distinguish, my lord. The distinguishing
Will
feature has to be
distinguish.
among the.
This court will distinguish. All right.
My lord, my lord, very respectfully,
Just
the
provide
distinct.
the judgment. Just provide the judgment and instruction. Next week we'll take up.
Yes.
Mr. Sagar, we'll take up next week. You
Please.
That's all the, I mean, you get this judgment which relied on by this thing.
My lord, a specific date may be
senior-
fixed. It would be very.
And the copy of this instruction also be provided to.
Furnished them.
Okay.
Please. My lord,
Or
any
Mr.
specific date may be fixed. I'd be grateful if.
Mr. S. Sagar Roy.
Please.
S. Roy, learned counsel for the petitioner. And also Mr. S. Tapit, learned senior government advocate for the state. Mr. P. Tapo for respondent number
3, Madam.
respondent number 3.
Yes.
Mr. P. Tapo, learned counsel for the respondent number 3 has produced a copy of the instruction as directed by this court on 8/11/2022. The copy has been duly shared with the learned counsel for the petitioner. On the prayer of Mr. S. Roy, learned counsel for the list this matter on 29.
My lord, any date except 28th and 29th. I have a dental surgery on 28th, my lord. So I'll not be able. My lord, maybe 30th or 1st or anything. my lord.
30/11.
Please, I'm obliged.
But we're going to dismiss it.
My lord, I tried to convince the court, but I'll graciously accept whatever the court decides.
It's not ready. And then when we don't think. This is,
My lord.
what is this?
My lord, I participate in NIT, my lord. Now,
NIT of what?
NIT is pertaining to my lord, construction of road, my lord, PMGY road, my lord. That is, my lord will find that as page number 32, my lord.
Thirty-two,
my lord. Construction of road, my lord. Under PMGY road, my lord. District Reparata, my lord. With total costing amount 13 crore 63 lakh 93,000. What happened, my lord? I participated, my lord. Now, after participating, my lord, on 13/11, my lord, I was informed with email, my lord, saying I'm non-responsive, my lord. My technical bit is not responsive, my lord.
okay,
That is a simple, my lord, intimation I have yet till that I have received, my lord.
where it is?
My lord, that my lord will find that at page number 44, my lord. 44, my lord. This is a e-portal, my lord, generated notice, my lord. You are informed that your bid for above tender has been rejected during technical evaluation by duly constituted committee for the region non-responsive, my lord. Now, no, down below, in any clarification or feedback, you are contact tender. I need to contact, my lord, how the region to know the reason for my rejection, my lord. Now, at page number 45, my lord. 40.
Yeah, you contact, what is the reason?
I have contacted, my lord. Even, my lord, my specific case is that they have disabled the whole e-portal, my lord. Beyond page number 45, my lord, I have annexed page number 45. Beyond this, my lord, nothing is accessible, my lord. Now, I submit a representation of page number 46, my lord, 15/11, my lord. Categorically.
You take instruction, we'll see tomorrow.
Yes. And my
technical bid has been open.
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 And when
When financial bid was fixed yesterday, whether it's open or not, I
we'll
have
see
no
tomorrow.
idea.
Heard Mr. El Parmelani counsel for the petition. Mr. Jeetar, learned counsel for the learning standing counsel RWD is directed to obtain the instruction. This matter tomorrow.
Obliged.
There's 22nd, 22nd 11/2022. You take the same.
Yes.
The bid evaluation report, summary as well as that.
Oh.
You get that. No, it's not possible. It's from Basar.
Basar, my lord.
It's
But,
not
but,
from email you can ask
yes,
from email.
if allow, my lord, this can be reached through here also, my lord, by e-portal, my lord. If they enable the portal, my lord. Now, what they are doing, they disable.
If he furnish, we'll share with you.
Yes.
Then you file a first petition.
Yeah, my lord. Highly always, my
This is only your ground.
Yes, my lord.
That you have been informed only that your bid is not responsible.
Yes, my lord.
And you are directed to contact with the tendering authority.
Yes, ma'am. I try to contact my in written also I have contact, my lord, but they are not responding, my lord. They are not giving me the on what ground I have been, my technique been rejected.
So
No, he should have go to the division and.
Instruction, huh? Including the instruction, including the ground of rejection.
Yes.
Similar
Minute of
summary
the, my
as you
lord,
bring the summary.
if my lord, is minute of the technical evaluation,
Huh?
minute, my lord, of the technical evaluation.
No,
That will be
whatever
good.
instruction is. Basically, that evaluation.
Yes, ma'am.
Minute summary. everything
Summary.
You get it.
Yeah.
Like today. That's it.
Obvious, ma'am.
Mr. So and so, learned counsel for the petitioner submits that he may be permitted to withdraw his writ petition. Writ petition,
No, IA
what IA?
for
Implement.
implement as a party.
You have filed it for implement.
Yes, your lordship.
Okay. You being a what?
I have been awarded a tender.
Not that about he is the successful bidder now, as of now.
Successful bidder.
Yes,
Okay.
independence.
What about this petitioner? Have you not served copy to the petitioner?
This morning I gave extra copies while filing.
Huh?
I gave extra copies in the registry.
We'll see tomorrow in this case.
Tomorrow, yes.
This is fixed on 28,
No, this is after 2 weeks.
after 2 weeks.
Hmm.
You furnish the copy, you have furnished the copy.
Yes. No, through the registry.
No, you have to furnish to the IA, this petitioner, counsel for the petitioner.
The extra copy I gave to in the filing branch to yes, then I'll serve him.
Huh?
I'll serve him extra copies.
We'll list it tomorrow.
Yes.
List this matter tomorrow. IA, no?
Yes.
Somebody had mentioned for.
That is fixed for tomorrow. Withdrawal is.
Tomorrow,
Yes,
you
sir.
serve the copy to the counsel for the petition.